Good evening to you, and thank you so much for having me on the platform. Yes, it is a minefield, and I'm hoping that we can deactivate a few legal issues and bombs in the course of the evening.
Rumbi, it's a pleasure to host you here. We're going to talk about COVID-19 as well as the marriage bill. So, COVID-19 has been such a menace and has revolutionized our ways of living and modified a whole range of things in terms of social interactions, business dynamics, and policies and legislative frameworks and all that. And what you do find is that countries have done all manner of things to be able to protect themselves and protect their citizens in so many ways. What you then find is that there is, confusion of sorts, in terms of, what's legal and what's not legal, what's doable. For example, there has been talk about is it legal for companies to institute mandatory vaccination without giving people the right of refusal, and even issues like medicine, and using medicine on pregnant women, or even administration of medicine in general without consent, and all that. And a lot of countries are still grappling with that. And what we found is people are also dodging um, um, the provision of certificates by going underhand and getting fake certificates, and it's been blowing up in people's faces, and also it puts everybody at risk, and companies have really been grappling with that. What we've found is that there has been a coordination of sorts in the global north, where, for example, if it's in Europe, you've got the EU working together across countries to develop mechanisms that connect up countries around response and prevention of the spread of COVID-19. For example, the EU digital COVID certificate has been quite instrumental in facilitating travel. And obviously, the provision of it is obviously determined by whether someone is negative and all those kind of things. Each different countries have also instituted different legal frameworks. For example, here in Ireland, we've got the Health and Criminal Justice Amendment Act for 2021, which gives the Minister of Health power to make regulations to introduce measures to slow down the spread of the virus. Under that act, the minister can restrict travel to and from Ireland, restrict travel within country, and stop gatherings of people. And under the Health Act 1947, which again has been amended, and it sets out restrictions around businesses, hotels, and other services. And also the Health Act 1947 also can give, police actually can give a fixed fine, and all that. But when you go down to Africa as well, there has been, extensive amount of, restrictions that have been put out. There has been passage of law, regulations, orders, decrees, executive orders, and all those kind of things by a lot of countries. For example, there's been 17 declarations of state of emergency. There's been 9 declarations of disaster and calamity, and then there's been 2 state of health alerts, for example, in Mali and Guinea-Bissau, and many others. So, what is the situation in Zimbabwe? I think Zimbabwe has done really well in curbing and containing the spread and the morbidity and maybe mortality from COVID-19 infection. It has been great at going ahead of the countries in the region in terms of the provision of COVID-19 vaccines from China and all that. But what is the legal framework that is informing this? What are the protections, even around insurance? What then are the safety nets for people that don't have access to insurance, especially because we are in an informalized sector, as informalized economy, where a lot of people can't afford to have insurance and all that. So can you just bring us into the world of the legal in terms of all these things? Thank you.
Thank you, Tendai, for that question. I think the first thing when looking at the COVID-19 situation, the corona pandemic, the calamity, the catastrophe, whatever you want to call it, it is all relating to a very bad situation. So I will hasten to underline that and to really put a line in the sand around that. COVID-19 and the situation is it's a public and worldwide emergency, and there have been so many deaths, and as the world has been affected, not only Zimbabwe, outside of all of that, it is really a global problem. And the manner in which this particular disease spreads also makes it very problematic, and the risks of an all-out, almost an atomic effect in the spread of COVID, like a nuclear bomb, if you like, and the mushroom just spreads. The risk of this is so high. It calls on everyone, particularly world leaders who are the heads of state and government, to make decisions that protect their citizens. In that vein, Zimbabwe has come to the party in terms of putting forward these decrees. So a state of this public emergency was indeed also recognized in Zimbabwe, and what followed were statutory instruments and presidential decrees through the various statutory instruments for the public containment and protection of citizens of Zimbabwe. So the statutory instruments ranged from, I believe, 83, and then with several amendments then to lockdown regulations that then leave us currently at lockdown level 2. Further to this, there has been a very concerted vaccination drive in Zimbabwe. Zimbabwe coming out, I think, third in Africa, behind Egypt and I believe Morocco, doing quite well in that regard, and even ahead of a lot of countries outside of Africa as well. The main thing about the vaccination was that it is and will remain a voluntary process. What this means is that COVID has come around, but the constitutional rights that were in place and in effect protecting the rights of Zimbabwean citizens have not gone away, and those are still there. So perhaps the question now is the how many, how do we strike how many? For example, it is a constitutional right. It is also in terms of public safety that no one has the right to have medicine administered without their consent. You can actually object to any administration of medicine and give reasons, be it religious or medical or otherwise. So there are avenues there, and these remain extant. The issue now comes about when you are trying to balance, and you must never be put in this position, trying to balance lives and I suppose livelihoods, and also the duty that the state has legally as well to protect all citizens. That then the mandatory vaccination came into effect for a certain section of the population, and these are people that are commonly known as civil servants and are under contract and have signed contracts of engagements, and so their relationships with the state are contractual, and they have bound themselves to obey instructions, and in that regard, getting vaccinated was one of those. But there were exceptions and clauses left there for those who did not want to get vaccinated for medical reasons, for religious reasons, or for any other good reasons. They simply needed to state these reasons. But again, the issue here is the public safety and trying to contain this pandemic, this disease that could spread like wildfire, versus this right. So you then find that what then sort of happened was, or what is happening, is a case where these two rights are now rubbing together, and one is obviously having to come on top of the other. But then don't the civil servants, don't the persons who don't want to get vaccinated have a right to put this across? And in answering this, then the answer is, if you do not want to get vaccinated, you will have to obtain a COVID negative test, or you have to get these COVID tests done regularly at your own cost. And then this becomes rather restrictive. And it's if you make it difficult for someone to exercise a right and experience it, it's almost the same as having taken it away altogether. So this is the position. And so you find that the mandatory vaccination is coming in on that front when we look at civil servants. Or rather, I will come back to the contractual relationship, where the contractual obligations then become superior to some of the rights of preference that these employees may have. But to what extent is it now contravening a constitutional right? And this apparent wrestling between rights becomes a real issue. So you also found players in the corporate world saying no jab, no job. Some then took this further and have been taking their employers to court. But now this creates a lacuna, because what has been decreed are statutory instruments, are regulations. They have not yet been put together into an act of parliament. So there is a temporary effect to the decrees made in them. And the question then again comes back to, what are we doing to harmonize the situation? We need to have a standalone concrete in a standalone concrete and very, very explicit laws that relate to COVID and the COVID situation. So far, it has been rather reactive in that respect. And then there is also another very interesting aspect, the apparent pressure on having vaccination cards, and then going further to say, we will then restrict your right to access certain places, your right to freedom of association, because we want to protect you. So it's a temporary measure whilst COVID is still a threat. It has also seen the levels being reduced, and I suppose a relaxing of these conditions, and now putting forward, say if you are vaccinated and you present your vaccination card, then you will be able to visit restaurants. You will be able to go to bars, which was received with quite a lot of jubilation by some sections of the population. And perhaps they didn't just went on to be vaccinated, not to protect themselves, but to be able to enjoy libations and to be able to have access to public places. Then there was this scenario around the constitutional right and freedom of worship and association further, where a decree was issued by the president that the unvaccinated would not be allowed to attend church. And this case was taken up by the Zimbabwe Lawyers for Human Rights, and they then actually got an order that declared that particular section, or that particular effect of restricting and denying people from enjoying their constitutional right to worship was declared null and void. And a step backwards was then taken in accordance and in compliance with this ruling, and this then was reversed. And it then again came to a head where the decrees also spoke about criminalizing and arresting perhaps a person who's gathered people together, because again, I come back to the public safety argument that has to be considered. And it's really quite a delicate balancing act. What do you put first in that instance? Your right to worship, or for you to protect the nation and ensure that they do not succumb to the COVID-19 pandemic, with a third wave really trying to be avoided. So that's a look at what the legislation states at the moment. The other pressure that I was referring to just briefly there, in putting these restrictions forward, has seen a lot of people resorting to getting fake vaccination cards. You would want compliance because people understand why they must get vaccinated, what benefit it will have for them and for their families. The approach that's been used by the global north has been rather more carrot than stick. And this has seen a lot of education going out, people being vaccinated and understanding what it means, research being done on the effects on children, on pregnant women, on people with certain underlying conditions. So I think this approach has seen more of a willing engagement by the population, and vaccinations being in high numbers. And because the global north has achieved high numbers and herd immunity, they're able to open up their economies and get back to business as usual, as it were. So I also believe that that's an important factor. What is the method that we're using to either inform as well as steer our people into the right mindset around vaccinations? It also went as far as even incentives being offered for people to get vaccinated. In New York, they were offering, I think it was $100 for people to get vaccinated. And you see that it's just really about the approach, because you're dealing with that delicate balance. You cannot take away these constitutional rights. And I think perhaps we need to come up with a better strategy in terms of trying to get people on board. You catch more flies with honey than you do with vinegar. And there's really a gap and a lack of legislation. So far, it's been reactive. It would be good to have labor laws that relate to what happens when an employer forces an employee to get vaccinated or lose a job. Can the employee sue for damages? At the moment, there is no law that relates specifically to COVID. Then the criminal aspects as well, and we would also like to see a reduction in the high numbers of fake vaccination cards. Nurses dealing in issuing out fake vaccination cards to quite a lot of people, because then we put ourselves back into the fire and out of the frying pan in terms of being susceptible, I beg your pardon, to catching the coronavirus, and to many people dying as a result. You raise a very valid point and make a very crucial example that also just reinforces that aspect of protecting the public when it comes to these sorts of diseases that will pose a risk and a danger to others around you. And interestingly, TB is still one of the most infectious diseases. Second, I suppose, now COVID has come in second to that. So it really then puts it in focus and in perspective that there is quite a very stern legal obligation that the state has to protect us, its citizens. A very difficult balance to have to strike. But I think in answering that, it's important to go back to the mischief that these regulations are intending to arrest. And it is an unforeseen pandemic with grave consequences that is very infectious. In that regard, I think the focus becomes protection, immediate protection, making sure that you live to be able to realize those rights. Someone put it quite crudely, and they said that hunger or suppose grievance is a fortunate is a fortunate consequence of life, of being alive rather. So in that vein, the idea is to arrest the effects of COVID and get back to a state of normalcy so that the restoration and enjoyment of rights can be restored. And I think that's the idea. The people who do not want to be vaccinated, it then begs the question, why? If there are religious reasons, they can be stated and they must be stated, and you can't then force someone outside of that. But they should not then become a spreader. They should get tested often. Then at whose cost does that testing come in at? Then becomes the question. So it's really a question of trying to restore normalcy, and this is the mischief that the laws, the regulations are trying to arrest, so that we can go back to a situation where I suppose these rights can be enjoyed in a normal, quote-unquote, setting. In my opinion, I really feel like the focus must then return to what has COVID-19 done over the past year, how many people have passed on, and that's when you realize that this is actually quite a serious problem. So the opinions, I think, cannot be, everyone has the right to assert their opinion, but I think in this case they are misguided. All hands on deck should be on making sure that this problem is resolved. But we must also have a robust health system. And I think it's been exposed in this COVID pandemic that the social safety nets, the public safety nets are not in place, or the ones that are in place are inadequate. The health system gravely needs an overhaul, improvement, and there need to be quite a lot of things that must be worked on. But I think these are all separate things in a way that all deserve attention. But I suppose they must be a priority in how they're dealt with. And we certainly cannot be having diarrheal diseases such as cholera and so on still being a problem. The health system is definitely in need of resurrection, in need of a jolt for it to be at par with world standards. There are also even issues of human rights that do come out. Then the issues, or what we often hear, is the issue of undercapacitation. Even the Constitution, when it speaks of rights, has a subclause that relates to resources being available. So how do we overcome the resource hurdle, the resource burden, as being where the buck stops, and the reason that we are given, and we often hear when these questions and opinions are put forward as to why they are defunct systems in that regard. The one thing that I think is really important as a takeaway point, even from this discussion, is that the law does not regulate behavior. It is the other way around, where we must be participating in these processes. Policymakers, doctors, people in these various sectors coming forward, perhaps presenting the information based on real statistics, the scientific information, and informing, I think, the people who then put the legislation down. I think it's about being involved in the processes, and more importantly, empowering the citizens by way of giving them information and an understanding of their rights. I think also that the powers that be, if I can call them that, these people at these different entry points in the value chain, in the legal value chain, must always do no harm first. And I'm confident, and I would like to believe that this is the reason why even when you take your oath to become a public officer and you take your oath to become a lawyer, this is what leads you forward. So maybe a reawakening and a reminder to the policymakers, to people involved in all of these processes, that at the heart of perhaps fighting the COVID pandemic, at the heart of the legislation around the COVID-19 pandemic, that it's all about safety. But in doing that, perhaps we need to look at putting in place laws that may preempt, and let's be proactive and perhaps do more consultative processes and get more stakeholders involved. The reason our Constitution is celebrated as one of the most dynamic and progressive in Southern Africa and so on in the region, and even beyond our region, is because it was a consultative process that took in absolutely everything, that measured 8 times before cutting once. And I think this is still very important at the heart of anything, not even the COVID pandemic, that has been dealt with reactively as an emergency. We must just have our house in order, but consult, and the policies must be far-reaching and involving everyone so that they are actually effective. Those would be my thoughts around that, and the incorporation of all those ethical issues. Again, they must be stated clearly and explicitly in order for them to be entrenched, and in order for them to be followed and adhered to.
Rumbi, I think you've heard what Mr. Mugabe has spoken about, and I think he highlighted a number of issues which have to do with the need for there to be spousal congruency, and the need for minimizing interference by extended family. He also spoke to the need for there to be, an investment in relationships, in spousal relationships, and all that. When we look at the marriage bill, where we have, the general law, which is, the 5.11, and then the customary law, as well as the civil partnership, and many other variant forms of the marriage bill. there doesn't seem to be harmony among those, where the 5.11 seems to be the supreme one. And everybody's vying for that, and those who don't even have it are discriminated against, and they always seem to be the losers. And then they go to great lengths and desperate lengths to assert their presence in marriages. But I think the marriage bill has managed to upgrade civil partnerships to a point where, as long as you've cohabited with a person, whether in a customary or otherwise, you are also entitled to inheritance of sorts and all that. Can you please then break down the marriage bill for us? How can we harmonize all three of them? And what are some of the provisions for the civil partnership that have been upgraded? And we're going to ask Mr. Mugabe to see if this is fair. If, for example, someone is in a long-term interdependent relationship with someone, then they happen to have an affair with somebody outside that partnership, and then they go and stay together while the other long-term relationship is still present, the other party is entitled to inheritance. What does that mean from a marital perspective? And I will ask Mr. Mugabe to comment after you've given us a download on your comments around the civil partnership and the marriage bill in general terms. Thank you.
Thank you so much for the question. Looking at the aspect of marriage legally, I want to mention something very quickly first, and it's underpinning all of this. Marriage is something that is voluntary. The Constitution says two people above the age of 18 who feel that they're ready to marry, who are not married to anyone else, can come together before a registered marriage officer in the presence of two witnesses and get married. That's about it. The other dynamic that we have to look at is the culture. We are African, and we have certain cultures and certain practices that were already alive and were already followed before the general law came into effect. So really, the genesis of the differences in marriages was that the Europeans, it actually has quite a big colonial underpinning, that the Europeans only were the ones who could be recognized to be married before God and the church. So the African the African people had to have a standalone marriage for them, which was not at par, and it was done deliberately with the general law marriage. It even cultivated an attitude in people that, if you don't have a chapter 511, or they will do the customary procedures and pay lobola and go through the dowry processes to the satisfaction of the bride's family, and then still proceed and get a chapter 511 and get a marriage certificate under general law. So our law recognizes three marriages. The general law, formerly chapter 37, which is chapter 511 now, and there's the unregistered customary law union, also known as the UKLU, and the registered customary law union. So the latter, registered and unregistered customary law unions, are potentially polygamous. This means that the man can have as many wives as he likes. If it's registered, that means each wife from Vahosi to the youngest in the harem can have a marriage certificate. When the husband dies, they are entitled to a portion of the deceased estate according to their position in that marriage. Then we move into chapter 511. It is monogamous, one man, one wife. If you're actually found to have more than one wife, it is a criminal offense of bigamy, and you could actually go to jail for doing so. But now, the issues around unregistered customary law unions are very, very important, because a recent survey saw that the majority of people who are married in this country are married under unregistered customary law unions. Generally, these are not considered as marriages by the law, except in instances of inheritance where a spouse dies. Then there's the aspect of a surviving spouse. The problem, however, is there's no proof. There's nothing that sets this marriage as having happened. There is no legal document, no legal provision around it. So it was problematic for a lot of women particularly, because when their husband would die, the family would come and say, oh, we don't even know that you were married. They would deny it. And it will be very difficult, imagine 20 years on, to look for the list that was used when your bride price was paid, to look for the tejara da munyai. People may have passed away. So in an effort to harmonize and to try and address some of these problems, the marriages bill was then brought to life. It is still in its consultative stages. It has gone back and forth to the people. It's gone back to Parliament and is still in the pipeline. It's not an act yet. If passed, it will put all these marriages at level pegging, meaning that if you decide to go the customary route, there is now a provision that will force you or will encourage you to register that marriage so that all marriages are registered. Then coming to aspects around, should the customary law unions then be monogamous? What do we do about the aspect of polygamy? We haven't quite harmonized those aspects yet. The Matrimonial Causes Act is an important part of this whole puzzle because it allows for distribution of property upon divorce in a way that is just and equitable. And this considers the non-material contribution of another spouse, say where the husband was working ordinarily and the wife was at home, but she's doing something. So there is non-monetary contribution that is considered, and there's a method that's used only under the Matrimonial Causes Act. So this is what the Marriages Bill is trying to arrest and to fix. Then the aspect of Section 40, which is the one that deals with civil partnerships. The mischief around this that was trying to be stopped was the plight that a lot of women were getting into, just like Tendai described, where you have an interdependent relationship, but you're not married. Perhaps the person is married to someone else, but that person is the one who has a responsibility to their spouse. And let's call a spade a spade. These things are indeed happening, and a lot of women are being left out in the cold after 20, 30 years of being in an interdependent relationship. No papers. When the spouse dies, they get nothing because at law, they're not the surviving spouse. So that was the thinking behind putting that clause in there, so that there is equal protection across the board. And just as an aside and a comment, the social aspects to marriage remain a personal choice, one that involves responsibility, one that involves accountability. We must also address and talk about the aspect of adultery damages. This means that if I find out that my spouse is cheating, say with Betty, I can sue Betty for breaking up my marriage, for contumelia, for loss of consortium, and still stay married to my spouse. So I feel like there's an anomaly in that as well. Maybe that should be addressed, because under customary law unions, you cannot sue for adultery damages because it's potentially polygamous. Anyone who is caught cheating with a spouse in that situation can simply say, I intend to take this woman up as my wife. So there's so many aspects around it. Marriage is sui generis, and this means it's in a league of its own. It's a unique contract that requires parties entering into it to be responsible and to abide by that contract. So social ills and irresponsibility and so on, I think, are just are just reactive maybe of the rot in the society. I don't know how to place my finger on it, but it definitely is very revealing, and people should be accountable for their actions. We can't then expect laws to be put in place to regulate behavior, to regulate morality. That is not what the law is supposed to do. It's people who should take responsibility for their marriages, for how they act when they make these vows, when they are bound to someone till death does them part. So that's also something very important. Another aspect that is brought out in the marriages bill is that chiefs and traditional leaders will also now be deputized as marriage officers, allowing more people to register their unions, allowing more people to actually put down their marriages, so that upon divorce or upon death, it's much easier for these people to be catered for, either in terms of inheritance or distribution and division of matrimonial property. Thank you for this question. The way that the Maintenance Act outlines this is strictly on an inquiry basis. This is considering the means of the responsible person and trying to balance this out with the needs of the child. This is so because you cannot order something that is not capable of being performed by the responsible parent, by the father, and it's got to stay within that ratio. Where there is need or justification for an upwards review, then that can be done. You can have maintenance reviewed upwards or downwards, as the case may be. But the law states, it's the law and the Maintenance Act that states that it must be inquiry based. It must be based on the means of the responsible person. I believe because there was an issue in the past where you would order someone to pay, say, $10,000, but if they earn $2,000, where are they going to get the $8,000 from? And if you ask someone or order someone to do something outside of their means, you have in essence robbed them of an opportunity to do it, and perhaps you're not putting the children's best interests forward. Again, maintenance is contributory. So this idea that only the mother of the child can go forward and seek maintenance and just have it paid without also contributing herself is something that needs to be corrected. As long as the mother is able-bodied and able to work, she must also contribute. Both parents must contribute, not only financially, but to the physical, to the spiritual, and the emotional well-being of their child. 8 times out of 10, I've found that people are using the courts to level unsettled scores and to be malicious, which is not what the legislation is there for. It's supposed to be used as a shield and not a sword. And I suppose it confers a lot of responsibility on people partaking in sexual activities or otherwise, that they think that there are no repercussions. So it's really difficult, and particularly, you're trying to regulate something that happens between 2 consenting adults and so on and so forth. So I think it really calls for a shift in mindset of the people who are getting involved in these situations. What do you think will happen in the end? So the law must come in and offer some sort of protection. It's unfortunately now being abused, but we cannot then take away that right, because there are negligent parents out there. They're negligent fathers, they're negligent mothers. By the way, it is a parent who has custody of the child who can claim maintenance. It doesn't necessarily mean that it's only the mother. Men can also claim maintenance depending on the case. The aspect of DNA tests and how this comes in and becomes topical is that our maintenance law simply states that if you allege that someone is the father and the person had contact, then it's fair enough. So if you believe or suspect that this person is the father, that's enough for an interim maintenance award to be awarded. This is because the issues to do with children are covered under Section 81 of our Constitution. So it's a constitutional right. If you fail to pay maintenance, it is actually it's punishable by imprisonment, and you can actually find yourself in jail. So that is why the courts are there and are acting, because they are the upper guardians of children, and they are there to try and harmonize and make sure that all children are looked after.
90% of the kids live with their mothers, not their fathers. So if you take the fathers, no matter how rich or how much money they make, they usually bring out the payslips, the RTGS money, and you think, okay, someone is saying he's a teacher. Yes, he is. He's earning probably, let's say, equivalent to $100. But this person is renting a $500 house, and that very same person is driving a $10,000 car. He actually came to court wearing a $300 suit, and sometimes even has a lawyer representing him. And then they say that person must contribute, let's say, 3,000 RTGS or 5,000 RTGS based on his payslip. But they're not going into lifestyle audits. The lifestyle audit would tell the truth. And then parents should split the bill half and half. They should put a benchmark to say, let's say kids from the age of 7 to 9, they need this and that, not want, needs, necessities. Both parents should do a 50-50, whether it's the mother, whether it's the father. I think that would be fair, because so far what we're seeing is women are getting desperate. When they get desperate, they end up because the other guy will be capable and the other one won't be.